The first case on the docket today is Paul Anderson versus Curtis B. Wagner, etc. Mr. Anderson here? All right, Mr. Anderson, you can come up. You may. Would you like to reserve any of your 20 minutes for rebuttal, sir? Okay, you may proceed.
Good morning. My name is Paul Anderson, and I am the appellant in the medical malpractice case of Anderson v. Wagner, case 505-3220. Before arguing for the reversal of the Ninth Circuit lower tribunal order granting a motion to dismiss with prejudice, I would like to make sure that you have all read the briefs, the record, the motions, and have issued orders on motions. Is that correct?
We have received and reviewed the record and the brief, sir. You can proceed with your argument.
Sir, I have a question.
You're not here to ask questions of the panel, sir. You're here to present your case and to answer any questions the panel might have for you.
The reason I ask that is because the appellant is concerned about the lack of constitutional due process. The appellant has filed 30 motions in this case. Aside from the initial motion for an extension of time, none of the motions have been granted. Additionally, the appellant has filed motions for clarification for Florida Rules Hotel Procedure 9.330A and been denied all motions for clarification. Therefore, I'm concerned about the process. Before I start arguing the order, Your Honor, I'd just like to mention one rule which is extremely important in this case. And that is Florida Rules of Judicial Administration 2.036 D3, appellate access to appellate review, which states, quote, litigants, including self-represented litigants, have meaningful access to a district court for mandatory and discretionary review of cases consistent with due process. B, litigants are afforded efficient access to the court for the filing of pleadings and for all arguments when appropriate. And C, orders and opinions of the court are available in a timely and efficient manner. Once again, orders and opinions of the court are available in a timely and efficient manner. Appellant is concerned because the appellant has asked for a persistent right for orders signed by judges in this particular case and received no orders signed by judges. At this point, I'd like to begin your argument. I just want to make that clarification. Your Honor, I'd like to proceed with arguing the order from the lower tribunal under de novo appellate standard review. Under de novo, Florida Rules of Appellate Procedure in the Florida Bar Journal cited that the appellate court can review the evidence from the record and come to a different conclusion than the lower tribunal. Your Honor, this is the final order from the lower tribunal. Quote, the court has reviewed the file, the motions, plaintiff's response to the motions, the applicable law, and heard arguments of defense counsel and plaintiff who was proceeding pro se. Your Honor, this is a misrepresentation of the facts. Plaintiff did not present oral arguments at the motion of this meeting, and to verify that as part of the record, plaintiff's affidavit, appellant's affidavit states unequivocally that the appellant did not present oral arguments at the motion of this meeting.
Mr. Anderson, let me ask you a couple of questions. I read the transcript, and I understand that it's clear that you chose not to argue at the motion to dismiss hearing because of your view that that was an unauthorized proceeding. Laying aside the question about whether it was or was not an unauthorized proceeding, I guess a couple of questions. The defendants in this case took the position that you failed to comply with the pre-suit requirements of the Florida Medical Malpractice Act. That seemed to me to be the purpose of that hearing. The only evidence in the record were the affidavits of the various health care providers. You didn't, as I understand it, testify as to your position was that Dr. Wagner failed to give you the records in a timely manner. But what evidence was there of that fact?
I have supplied, this is part of the record, Your Honor, a notice of intent invoking Florida Statute 766.204, stating specifically waiving the need for medical expert opinion.
Right. I understand what the statute says. My question, though, is that statute applies if the doctor fails to give you the records in a timely manner.
Correct.
They took the position in an affidavit form at the hearing that they had provided you the records in a timely manner. Your notice of intent said that they did not. My question, though, is what evidence did you offer to the court, either in the form of an affidavit or testimony, to back up your allegation that they didn't give you those records?
I was never given a chance to present an evidentiary hearing. I requested on August 10th an evidentiary hearing that was granted. The evidentiary hearing never occurred. On August 23rd, I was granted an evidentiary hearing. It never occurred.
But what was the hearing? My understanding was that the hearing before Judge Powell was the hearing at which this matter was considered. And why wasn't the evidence considered at that time?
Well, all three, in this record, R264 to R268, all three defendants consented to Judge Cohen only at that motion to sue him. I went into the room, I asked, where's Judge Cohen? He said, well, he's not here. I said, well, I wasn't know this one from the judge. He said, well, we're going to have this one here. I said, respectfully, Your Honor, I would not like to participate in these motions to sue hearing because all three consented in R264 to R268, where each of the defendants consent to Judge Cohen only here to lead that hearing.
But just so I have a clear understanding of the facts, if I understand the position of the defendants, they simply said in those filings that they would not agree to have preliminary matters referred to a magistrate judge and preferred the matter to be heard by the assigned Judge Cohen. Is that correct?
It consented to Judge Cohen. We had a hearing that was occurred with Magistrate Black. We both appeared, and it was canceled without any advance notice at that meeting. And at that point, they consented to try in R264 to R268, all three defendants, for all matters pertaining to the case, including the motion to sue hearing, to be heard by Judge Cohen only. When I came into the room and saw Judge Powell, I asked Judge Powell, Your Honor, respectfully, is Judge Cohen supposed to be in this hearing? And I told Your Honor at that meeting, I said, Your Honor, they all consented, it was approved. And he said, well, that has to be, I said, Your Honor, I would respectfully not.
Why do you feel, or I guess more specifically, what is your authority for the position that only Judge Cohen could hear this to the exclusion of Judge Powell, or for that matter, any other circuit judge of the Ninth Circuit?
The consent, you notice the hearing issued by the defendant, they consented to Judge Cohen, following the notice of hearing taken to Judge Cohen.
So your position is because the notice of hearing said that this matter will be heard before Judge Cohen, only Judge Cohen had the legal authority to hear it.
I'm not making that argument. I'm not in a position to say that. I'm in a position to say I went into the room and I mentioned to Judge Powell that all three defendants had consented to Judge Cohen. And at that point, since Judge Powell was not involved in the case up to that point whatsoever, Judge Cohen was the lead judge, Judge Cohen was involved in all the pleading and the filings. Judge Powell came in at the very end, and I just thought that was very odd and peculiar. I didn't mean any disrespect whatsoever. I was following what the instructions were.
I read the transcript, and you were very, very courteous, very polite to the judge. You were not disrespectful in any way. But what I'm trying to get at is, if the law says that the litigants don't have any right to any particular judge, in other words, as judges, we're considered to be fungible. You know, we look different, but basically, one judge is in theory supposed to be as good as the other. So if the law says that Judge Powell was authorized to hear that case, if he was filling in for Judge Cohen that week for whatever reason, I don't know if Judge Cohen was on vacation or tied up in a trial or a seminar, but...
Judge Cohen was hearing right before that. He was in that room. I looked at him in the face. And I was
Okay, but what I'm asking you is, I want you to assume for me that the law says that we judges are fungible and that all you have the right to is a neutral, impartial judge. You and the other side don't have a right to a particular judge. So if you assume, for the sake of my question, that Judge Powell was lawfully empowered to hear that case, what do you think that does to your failure to address their contention that you didn't pre-suit the case correctly?
That rule in Florida was supposed to be on, I'm curious to find out. I know that, I think it's 260 Florida Board of Judicial Administration that we're all to follow the Florida rules of federal procedure. Do they allow for judges, I'm just asking a question, I'm not familiar with that law. It allows for any judge to hear a case.
It's not in the appellate rules, but it's in the case law of Florida, that judges are interchangeable. So it's kind of like a baseball game or a basketball game. You know, you can bring somebody in on the bench, off the bench, and swap them around as long as they are otherwise qualified to hear the case. So I guess my question is, if you assume that what I've told you is a correct statement of the law, what does that do to your position then about the failure to address by evidence the contention that the defendants made that you didn't pre-suit the case correctly? See, here's the problem that I've got. From the record, they have sworn affidavits in the file that say, from Dr. Wagner, that says, we gave you the records in a timely manner, within the 10 days. There's a sworn affidavit. And that may or may not be true. I'm just telling you what the state of the record is. And there's nothing on the other side. That's my concern.
That affidavit violates the law. There has to be time. The person who swore to the notary public of that affidavit, which is not now, is a party and has a financial interest in that affidavit. The law specifically states that you cannot have a person as a notary have a financial interest in that transaction or be a party to. These are mouses at the time working with Dr. Wagner's lawyer. So to me, that it seems a little bit weird that you have that conflict of interest. She was a party and she had a financial interest in verifying that affidavit and violating the law.
Sir, did you argue to the trial court that the affidavit was illegal for that reason?
I was never given the opportunity.
Well, the reason you weren't given the opportunity, at least in part, was because you refused to participate in the hearing when the affidavit came up, correct?
The affidavit never came up in the hearing.
I'm sorry, were you there for the whole hearing?
I was there. We were both there for the hearing. We went in. We asked Judge Powell to change the hearing because, once again, Judge Powell was not involved in the proceeding at all up to that point. He showed up in the room, and I asked the judge. I said, Your Honor, he said it's fine. He said, you can decide not to participate, that I wasn't breaking any law or anything like that. He said, you have the option of not participating in these hearings. That's in the transcript. And I said, Your Honor, thank you, respectfully. I said, since Judge Cohen was consented by the defendant, and Judge Cohen's not here, I'd like to reschedule this. And he said, well, you don't have to participate. I said, fine. We sat there quietly. I'm going to tell you exactly what happened. They granted the motion to dismiss hearing. They presented, I guess, one or two documents of evidence. And at that point in time, I didn't do the evidence, but I looked at Judge Powell and I said, Judge Powell, there's proof of evidence in the transcript that is a criminal or felony. I'm not sure which word was used. And I said, I think you should review that evidence before you dismiss the case. And he came down pretty well. Don't you ever say that in my courtroom. And I just sat there. That was it. I did not present evidence. I did not argue the case. I told him about the criminal. I don't know which word was used. But I said there's evidence in the record. Please don't dismiss this case. And when he came down hard on me, I just basically, at that point, we sent over.
Okay, but at some point, were you served with or given a copy of these affidavits that you say are illegal? The affidavits that you say were improperly notarized and therefore violated the law. At some point you had those affidavits, correct? Or a copy of those affidavits? Otherwise, you wouldn't have been able to come in here and argue who notarized them and why that notarization was in.
They are part of the record.
Okay.
They are part of the record.
And so you had copies of those at some point, correct?
At some point.
All right. When you got your copies of those affidavits, did you file a motion with the court to strike them? Did you do anything to argue to the trial court that they were in violation of the law?
They were never presented. They were sent to me. The affidavits were sent to me. There was never a hearing set up by the defendants on the affidavits. You can check the record. There was never a hearing on those affidavits. I wasn't given the opportunity. There was no hearing on those affidavits, so I can challenge the veracity of the other affidavits.
Wasn't that the purpose of the motion to dismiss hearing, where you could have, well, hold on. The purpose of the motion to dismiss hearing was to give both you and the other side the opportunity to offer whatever evidence you wanted to on this issue of whether or not you complied with the pre-suit requirements. And so I guess I'm a little bit mystified. Right, I understand. But my question is, when you say that you weren't given the opportunity, wasn't that your opportunity, and didn't you decline to take advantage of it?
I did not set that meeting up, Your Honor. I requested multiple times from the court evidentiary hearings were denied repeatedly. I did not have an opportunity to present the evidence, which I would have considered due process if I would have had that chance. That meeting was scheduled once again. We'll have to ask them, but it was scheduled by the defense with the motion dismissed, motion strike. Actually, the meetings that were filed, I did file responses. I did file responses to a part of the record on the motion to dismiss and motion to strike, letting the court know I had not had an evidentiary hearing, and I made several arguments for why I felt dismissal was unwarranted at this point in time. I didn't present any evidence, and the case was being dismissed before I had a chance to, I'm the plaintiff in the case. Usually as a plaintiff, you've got to prove your case. I wasn't given an opportunity, Your Honor, to prove my case at the trial court level. I wasn't the case. This was out that opportunity.
Let me ask you this. Let me shift gears for just a minute away from Dr. Wagner, and let's talk a little bit about Dr. Thompson, who I understand was the anesthesiologist, and the Orlando Surgery Center, which I guess was the place where the surgeries were performed. What pre-suit expert affidavits were offered with respect to those defendants, if any?
Under Burbank and Carroll, which was a decision for this court, in terms of notice of defense, that once you file a notice of defense under Burbank, that the defendants, the statute of limitations told us defendants also, there's a relationship, a legal relationship between Dr. Wagner, the anesthesiologist, and the surgery center. They are tied together. And so under Burbank, notice to one serves as notice to all under the statute of limitations. However, I did go to the pre-suit with the surgery center. I sent them a letter, and it's part of the evidence.
All right, I saw it.
Okay, I did, because this case was originally filed on March 9th. But I made the complaint to make sure that all defendants were included in the pre-suit. I went to the pre-suit with the Orlando Surgery Center, served them with the papers, served them the original notice of intent.
Was there an affidavit from an expert?
No, in the actual serving of the papers, I told them I invoked the 766.204, which raised the requirement for an affidavit.
So your argument, if I understand your position correctly, your position is because you think Dr. Wagner didn't comply with the pre-suit service of records in a timely manner, that he waived his right to pre-suit the case, and that as a result, the other defendants likewise waived their right to pre-suit the case.
My position is, in the notice of intent, once again, was that on August 27th, I appeared to Dr. Wagner, August 27th, 2003, I appeared to Dr. Wagner's office, and at that point, 2002, the first DPA, the 766.204 held, being that Minty went to the department to request medical records that weren't supplied within, he was denied medical records within that 10-day period, and as a result of Minty versus Moore, 76204, if you are denied medical records, I was denied on August 27th, Your Honor. I was also denied in a writing. I sent a letter, and I have a letter for it.
I saw that. My point, though, is, let's assume that all is true. How does that affect your pre-suit requirements with respect to Dr. Thompson and the surgery center?
Once again, I did serve the notice of intent, the written statute of limitations to the surgery center.
Right. My specific question, though, deals with the requirement that the statute says that you have to have a corroboration from a written medical expert opinion.
Once again, under 766.204, if you're not giving your full medical records within a 10-day period, then you don't need a medical expert opinion.
Okay. So if I'm correct, your argument is that because Dr. Wagner didn't give you the records in a timely manner, then you didn't have to give a corroborating affidavit to Dr. Thompson or to the surgery center.
Under Burbank, where the defendants or the evidence can be added, based on the original notice of intent, originally, so you're right, Dr. Wagner did not supply the medical records, waived the requirement. Under Burbank, the statute of limitations is called for all defendants, and the defendants, the surgery center, and Dr. Thompson have a legal relationship. A legal relationship is the key in Burbank. There's a legal relationship, and actually, there's another thing, but the key here, Your Honor, is the legal relationship which exists between the defendant and the pre-suit requirements that are applicable to all defendants.
Thank you, counsel. Your time has expired. Mr. Anderson, your time has expired. I understand, but your time has expired, sir.
Good morning. May it please the Court, my name is Michael DeLugo, and I represent Dr. Curtis Wagner and his professional association, Foot and Ankle Specialists of Florida. I'm joined here today by co-counsel for the co-appellees, Rich Barry on behalf of Dr. Thompson, and Paula Late, who is here on behalf of the Orlando Surgery Center. There are certain factual distinctions that apply to each of the three appellees, but for ease of presentation, I would like to try to field all the questions that the panel may have. But I would like to ask that I have the opportunity to reserve 2 minutes for Mr. Barry so that he can make a presentation on behalf of Dr. Thompson and so that he can answer any specific questions that the panel may have as to Dr. Thompson.
You all can use your 20 minutes any way you want to divide it up.
Thank you. This is a very simple case. This is a claim of medical malpractice. Mr. Anderson requested his records from Dr. Wagner's office on August 27 of 2003. He was provided those records on September 5 and September 6 of 2003 within the 10 business day requirement of Florida statutes.
All right, let's just stop there and let's address what record evidence there is to prove the contention that you have that you timely served him with the records.
The record evidence is the affidavit of Dr. Wagner, in which he indicated and testified under oath in the form of the affidavit that he did provide, or his office did provide those records to Mr. Anderson. Attached to his affidavit as an exhibit, there is a photocopy of the green return receipt card that went along with those records, signed by Mr. Anderson, indicating that he did in fact receive those records.
And to what extent, if any, was that affidavit rebutted or contradicted by any evidence offered by Mr. Anderson?
To my knowledge, there is no evidence in the record to contradict it. The affidavit stands alone.
And was that the basis, as you understand it, of Judge Powell's decision to dismiss the case because of the failure to comply with the free suit?
Yes, Your Honor. Mr. Anderson invoked Florida Statutes Section 766.204, in which a party who requests records and doesn't get them is allowed to skip the requirement that you provide a corroborating expert to indicate that there is, or that he has reasonable grounds to support a claim of medical malpractice. he was provided the records in this case. Therefore, his reliance on 766.204 was misplaced, and that was the determination that Judge Powell made at this hearing.
And the motion to dismiss that you filed was based upon the affidavit. This was not a motion to dismiss within the four corners of the complaint, correct?
That's correct.
It was based upon affidavits filed with the motion?
That is correct. It was based upon the statutory structure that the legislature has set up for initiating medical malpractice claims. So by definition, Judge Powell did have to go outside the four corners of the complaint, although in a typical negligence case, a trial judge would be limited to the four corners of the complaint because the legislature has created this statutory scheme of pre-suit that a plaintiff must comply with prior to going forward with the case. Judge Powell was allowed the opportunity to review the affidavit of Dr. Wagner in order to make a factual determination as to whether or not the records were provided.
And was the affidavit served with the motion to dismiss prior to the hearing on the opposing party?
Yes and no. It was served prior to the hearing, but it was not served at the same time as the motion to dismiss. The affidavit was executed, if I have to get my dates straight, I think the motion to dismiss was served on May 2 of 2005. The affidavit was executed in June of 2005, and the hearing on the motion to dismiss took place on August 2nd of 2005. So to answer your question, the affidavit of Dr. Wagner was submitted prior to the hearing, but not at the same time as the motion to dismiss.
And was any response filed to the affidavit, either a motion to strike or an argument that the affidavit was somehow in violation of the law or improperly noted?
The argument has been raised in the context of this appeal that
in the trial court. My question is at the trial court level.
No.
Was the argument made to the trial judge that the affidavit shouldn't be considered for any reason, including it was improperly notarized?
No. As I noted, there were certain distinctions between or among the co-appellees here. In addition to the Dr. Wagner's position that the motion to dismiss was proper because pre-suit was not done correctly because there was no corroborating affidavit. As to the Orlando Surgery Center, the correspondence that Mr. Anderson sent on March 16 of 2005 does not qualify as a notice of intent to initiate medical malpractice litigation. In effect, it was merely a cover letter enclosing a copy of the pre-suit notice that was sent to Dr. Wagner. And in fact, Dr. Thompson is even further removed in that there was nothing that was served to Dr. Thompson to put him on notice that there was a potential medical malpractice claim. And Mr. Anderson has raised the issue here today that there was a legal relationship among the three entities, the Dr. Wagner who performed the surgery, Dr. Thompson who provided the anesthesia for the surgery, and the Orlando Surgery Center. In fact, there is no such legal relationship. These are all completely separate entities. Dr. Wagner...
Is there evidence in the record one way or the other on that issue? What do we have before us in the record that would allow us to say whether they were or were not connected or independent of each other?
Dr. Thompson did submit an affidavit that was unrebutted that indicates that he is not an employee and in fact has no legal relationship with the Orlando Surgery Center. So there is record evidence that was uncontroverted to that extent. There was nothing that was submitted on behalf of Dr. Wagner to suggest that there was no relationship between Dr. Wagner and the remaining two co-defendants. But I don't know that that wasn't really an issue with the trial court. I'd be happy to entertain any additional questions that the panel may have. Otherwise, I will take my seat, and if Mr. Berry has anything to add, I will allow him an opportunity to do that.
Thank you.
Thank you.
No, you may not, sir. Your time is up.
Good morning. May it please the Court. My name is Richard Berry, and along with Ralph Martinez, I represent Stephen W. Thompson, M.D., an anesthesiologist. And very briefly, for the Court's benefit, I will simply state that the issue as to whether records were provided in a timely manner to the plaintiff in the pre-suit period does not apply to Dr. Thompson. As co-counsel has indicated, Dr. Thompson is further removed from the issue than either Dr. Wagner or the Orlando Surgery Center. Dr. Thompson instead was only given actual notice of this potential claim at the time the complaint arrived in his office with a summons.
What was your response to the complaint? Did you file a motion to dismiss alleging failure to comply with the pre-suit?
Correct, Your Honor.
Was there an affidavit from Dr. Thompson about concerning the issues that you raised in your motion?
Yes, sir, Your Honor. In fact, there was an affidavit that we submitted with from Dr. Thompson that indicates his status as a non-employee and bearing no legal relationship with the other parties in the case. Obviously, the Duffy motion that we filed, or based on the Supreme Court case of Duffy, looking for an evidentiary hearing to determine the compliance or non-compliance with the pre-suit provisions by the plaintiff was the motion we filed, and it was accompanied by that affidavit. About the affidavit specifically, I'd like to inform the court that co-counsel, of course, is correct. That affidavit was in there. It was uncontroverted. And the issue as to Dr. Thompson, of course, is that he had no notice at all until the complaint was filed. And with that, Your Honor, I'll field any additional questions the panel may have.
Thank you, counsel.
Thank you.